Lordship, I beg to mention item number 6. In this particular matter, there are two matters connected. So we have just been engaged. I have filed my wakalatnama today. So I pray for 4 weeks time to do the hearing.
Miss, it's a 2016 matter.
My lord, but then we have just been engaged. I filed the wakalatnama today only. That is why I pray for a single 4 weeks opportunity so that we don't need to seek further adjournment in the matter.
What is this matter about? Disciplinary issue?
My lord, it is some service matter. Actually, Mr. D.K. Das is the conducting counsel. I'll just be assisting him. The records are with him. It's not with me.
And who are the...
My lord, Union of India. She's appearing for the
No,
union.
you're appearing for?
Petitioners.
Petitioner?
Yes,
Mr. Sangreso was the earlier...
Yes, my lord.
Petitioner?
Yes,
counsel.
my lord. Counsel for the petitioner. So in these two matters, in fact, some of the petitioners have retired or expired also, and then the names of few petitioners have been struck down as far as my instructions are concerned. So we have filed wakalatnama on behalf of the other petitioners who are still fighting for their cause.
Miss P. Garwal, Learned Counsel for the... Learned Counsel, have you filed your power?
Yes, my lord, just today.
Learned Counsel for the petitioner has submitted that the petitioner has recently engaged fresh counsel, and as such some time is required for the brief to be perused and the matter to be pursued before this court. In view thereof, the matter is the prayers allowed. As prayed for, this is matter up to 4 weeks.
If a fixed date could be given, if it could be on 26th of May, my lord.
This is matter on 26th May.
Deeply obliged, my lord.
May it please your lordship. Your lordship, I beg to mention item number 8.
Yes.
Your lordship, we pray for 2 weeks time in this matter, your lordship. The learned DSGI is out of station due to some emergency. He had to leave, your lordship.
My lord, it is their instructions.
What is this matter about, Mr. Jha?
My lord, this is the discharge 2 years ahead.
Oh.
On the
ground.
My lord.
On prayer made by the respondent, not objected to by petitioner. This is matter to 2 weeks.
Much obliged.
But there are 2 matters involved here, Mr. Jha.
2 other matters.
Same,
my lord. That is ADS alcohol. On medical ground, they are.
EDS. Fine.
May I please, your lordship, I beg to mention item number 9. Lordship, I'd like to pray for 3 weeks' time as the conducting counsel is out of station due to some emergency, your lordship. I've informed the...
I've already informed your lordship.
On prayer made by the respondent, not objected to by petitioner. This is matter to 3 weeks.
I'll oblige, lordship.
Please, lordship, I beg to mention item 7.
I have indicated that no more general will be given here.
The conducting counsel is out of station, so...
He may be out of station. This court has time and again reiterated that this court would respect the counsel appearing for the parties. But there you should also understand that this cannot be a ground for adjournment all the time. Being out of station doesn't give you the liberty to adjourn your matter.
Lordship, can we have next week, lordship, if your lordship permits?
On prayer made by the petitioner, seeking a judgment on ground of personal difficulty on the part of the conducting counsel, Learned Senior Conducting Counsel. That is adjourned. Listing after 1 week.
Highly obliged, Lordship.
Daily cost list, item number 1.
See, Mr. Sen,
Only thing I'll yes.
why this matter was mentioned, the fact being that it has been pending for quite some time, almost 3 months, and 3 months cannot, judgment cannot be kept pending for so long. Number one. Number two is why it was pending, or rather kept pending, is because the court was of the impression that there are, those related matter or issues or cases which, if any per se any judgment is passed in this case, would affect the argument of the parties or the case of the parties. That was the impression given. So this matter was kept away. But I think now
my lord,
we will have to
what I
decide.
pray also, my lord, before also while making submission in other case, I said, my lord, this matter, my lord, if I am, my lord, permitted, this lordship can list this matter again for hearing, my lord. My submission
Hearing
said.
was already concluded.
No, this hearing is concluded, all right, my lords.
Yeah,
But
it has to be.
that does not mean your lordship cannot hear it further. Why your lordship has listed it, my lord? Why it is listed to be spoken to? So
Exactly.
lordship can hear it again, no problem, my lord. So lordship, my lord, any date convenient to your lordships can post it for hearing.
Hearing is just to cover the formality of it being
Yes,
pending.
exactly.
Otherwise, practically the parties have filed their written
Which
argument.
arguments was already filed.
Argument have been advanced.
Lordship can hear it again, no problem, my lord. I am there, your lordships. And I don't know, yes, my lord, lordship can hear it. Any date convenient, lordship.
We'll list it together with those.
Other matters are listed, my lord, on day after tomorrow, my lord.
Day after
It's
tomorrow.
26th.
So we'll come up with that.
This matter has been mentioned specifically today on the ground that the same has been, the judgment reserved has been pending for quite some time. Though the impression of the court was that the matter may not be disposed of, considering the fact that there are similarly situated and related matters before this court, which in the submission of the parties would have a direct impact or bearing on the arguments of the party. If in those cases, if this matter is, if the judgment in this case is declared, be that as it may, on the submission of the parties that this case be released and be fixed for further hearing, the court is in agreement with the same, with the said submission. Accordingly, this matter is released and to be reheard on the next date fix as submitted. This is matter on today is
26th. Other matters are coming up on 26th.
26.
26th.
This is matter on 26 April.
Obliged.
Item number 2.
So where were we?
This matter pertains to remission.
That
But
Supreme Court matter.
This matter basically.
Excuse me.
My My lord, Mr. B. Dev is appearing in this matter. He requested me to appear today, but he has to go somewhere, my lord, for some urgency.
No, I think we are still on the yes on the ground that there is similar matter pending before the Supreme Court,
My lord,
where
my lord.
the issue of remission is being taken
My
up.
The state has already filed an affidavit also, my lord.
Yes, in that
And
case.
the very factum of this thing, rejection of the prayer of the remission of the petitioner, has been mentioned in the affidavit.
No,
which was filed in
here or in the Supreme Court.
My lord,
Have you appeared in the Supreme Court? But this is
no,
not
my lord, state has filed their affidavit in Supreme Court, my lord.
in Supreme Court.
And the
Any
petitioner's case,
any reference to this particular case
my lord, not to particular case, all the cases of remission.
of similar nature?
My lord, similar natures. State has filed an affidavit, my lord. And this is, my lord, this is a part of the writ petition also. His lordship will find it's there. This is second round of litigation, my lord. In the earlier round, we have filed that affidavit. In that affidavit, we brought in those, my lord. So this is a part of records now, my lord. At least it's before your lordship.
My lord, I'm praying if this matter can be taken up tomorrow, my lord, because he has to leave for some urgent work.
Tomorrow, it will be the Supreme Court. It's coming up on 25th July, my lord. So I don't think, my lord, if it is listed tomorrow, my lord, any effective order can be passed in this matter. The last occasion also, Mr. Dev did not appear.
Okay. So you suggest that we take it up after 20
My lord, that
July?
would be proper, I think. I do not know, because if lordship, my lord, kindly takes up the writ petition, my lord. Lordship, just for a moment. Lordship comes to, my lord, page 84, annexure 7. That is the affidavit which was filed by us in the previous round of litigation, my lord. My lord, lordship, if lordship proceeds to page 95, my lord, lordship will find, my lord, there we have appended a copy of the affidavit which was filed before the apex court, my lord. No, my lord, here, my lord, my lord, at page 103, my lord, lordship will find at paragraph 8 you have mentioned page 103 at paragraph 8, my lord.
Yes.
Lordship find, well, the paragraph 8, just small paragraph, if I can read it, my lord, that further it pursuance of the direction issued by this honorable court, the state government has also collected data of convicts lodged in various prisons of the state of Meghalaya who have been sentenced for more than 14 years and those who have been sentenced for more than 10 years but less than 14 years, which are 22 in numbers. The state has also obtained opinions of the concerned district judges as to whether their cases can be considered for remission or not. A tabular chart of the information of these 22 cases is follows, my lord. Now, if lordship comes to number 3, my lord, Lionel district judges opined against grants of remission. It is number 3, my lord. Now, if my lord, lordship, my lord, kindly come to my lord, page 106. There is the details of the tabulation, my lord. Lordship will find the name of the petitioner is there, my lord. See Nabam Thai.
Oh.
So, my lord, probably, my lord, it will be appropriate for us to wait for the order.
Should be. No, because since this matter is seasoned by the Supreme Court, if an order is passed, then that would be, contrary to judicial propriety. The Leonard AAG, Mr. B. Prasad, has again impressed upon this court that the subject matter of this writ is already an issue before the Honorable Supreme Court. And the case of the individual and the case of the writ petitioner herein has also figured in the affidavit filed by the state before the Supreme Court. And as such, any order passed before the disposal of the related matter before the Supreme Court, any order passed by this court would be improper at most. It is therefore submitted that this matter may be kept in abeyance till an appropriate order is passed by the Supreme Court in the said related matter, which, according to the learned AG, will come up for hearing.
It's likely to come up for hearing on
Likely to come up
25/7
for
2023.
On 7th,
25/7 2023.
25/7, 2023. At this point of time, this court would refrain from passing any order or comments on the merits of this matter. Suffice it to say that the submission of the learned AG does carry weight as far as the issue raised in this petition is concerned. Accordingly, this matter is kept in abeyance and the same is posted in the first week of August. Please accordingly.
All right.
Lordship, we took steps in this matter as regard to respondent 1, 2, 4 and 5. Lordship, however, service of notice upon respondent 2, 4 and 5, it has not been ascertained, whereas as far as respondent 1 is concerned, the AD card has been returned unserved.
Unserved. So only respondent 3 you are respondent 3. This is the same matter in which it has proceeded ex parte against this respondent.
Yes, Lordship.
Yes, we are supposed to apprise this court.
Yes, we need some more time, Your Lord. We need some more time.
The counsel for the petitioner has submitted that the notice on respondents 1 on respondent 1 has returned unserved, while no report has been received as regard the notice issued upon respondent 2, 4 and 5 respectively. It is therefore prayed that some more time may be allowed for the report on the said notices to be filed before this court. For the report of service of the said notices to be filed before this court. The learned counsel for the respondent 3 in the meantime has submitted that some more time may be allowed for the matter to be for the respondent 3 to clarify on the query made by this court as regard the requirement or rather non-requirement of the other respondents herein to be present before this court in these proceedings. On premium seems allowed. This is matter up to
3 weeks.
3 weeks.
Obliged, Lordship.
Item number 5.
Your Lordship,
Yes.
steps has been taken in part of respondent number 5, pro forma respondent number 5. The AD card is just received here.
Have you filed your affidavit of service?
Not yet, Your Lordship. No, not yet, Your Lordship. We'll file, Your Lordship.
And Lordship, we had got a status report, but there was some clerical error, Your Lordship. So we'll just correct it and submit to the court.
Status report?
Status report, Your Lordship. This case is regarding 133 of the CRPC. There was some issue. So on the last occasion, Lordship was on leave, so another court had to take up the matter. And the Lordship will just see the order of 6/4/2023.
Yes. What does it say?
So Lordship, a detailed order has been passed. So far step is concerned, we were supposed to give a status report. Actually, what is the status of the?
Oh, that's.
We as I submitted, Your Lordship, there's some clerical error in the typing mistake. Instead of 8 December 2022, and the concerned magistrate has mentioned 23. So we'll just like to correct and inform the court in the next day. In the meantime, if respond number 5, if the service is completed and what they have to say, because it's dispute between petitioner and the respond number 5.
Okay.
So state is just acting as a neutral body.
So firstly, we
complete the
complete the steps. Excuse me. We ensure that the respondent 5 is duly represented.
Absolutely.
And number 2, have you filed? You have filed a status report.
Lordship, as I said, there's some clerical issue.
Yes. So you have not filed.
No, we have not filed.
Oh, then that's
Absolutely.
You can do it.
Otherwise, we could have informed the court because it's later.
Okay. And the counsel for the petitioner has submitted that the respondent 5 has received the notice issued upon him. However, it is prayed that the affidavit of service may be allowed to be filed in due course.
Your Lordship, interim order may continue, Your Lordship.
Mr. AAG or Mr. K. Khan, another AAG has submitted that the status report could not be filed today since some corrections are required to be made in the body of the said report, for which some time is prayed for the same to be filed. How long? 1 week?
1 week, Lordship.
As prayed for, this is matter after 1 week. In the meantime, the interim order was on the
6/4/2023.
By this order, interim stay was okay. Now, where is the?
In fact, it's not exactly interim order, Your Lordship. The parties were directed. It's a long order.
Not to take coercive.
Not to take, Your Lordship. That will continue. It goes without saying, Your Lordship. We are not going to take.
Yes.
That was the reason for status report would exactly say what is it.
In the meantime, the order dated
6/4/2023
passed by this court in this case, particularly.
Lordship, if I may submit, the order of 6/4/2023 was not only till today. So there's no date mentioned. There is no question of extension of any.
Oh, then.
No. The last line, Your Lordship says only lists the matter on 24/4/2023. Had it been the case of if till today, then extension was
Yes, exactly.
definitely warranted.
Yes, this will, you see, anything, if there's anything done to you, detrimental to you, you produce this order.
Absolutely.
Paragraph 9 is very clear.
Very clear.
Tata, pom lao, Spread for this
We'll
matter.
continue. We'll wait for the service report on 5, Your Lordship.
Spread for this matter up to 1 week.
Item number 10.
Ten and 12, I think. And so 10 and 12,
Yes.
10 and 12.
Please.
Please, Your Lordship. In this case, my Lord, I will refer to the list of date, my Lord, which I have already furnished also to the Dishonorable Court. In 1920, my Lord.
You have given them a copy?
I think they have not.
No, madam. We have not received one.
Understand, huh? Article 2. Yeah. I'll continue. We'll just keep within a few minutes here. My Lord. In 1920, my Lord, Nishi Shekhar Pogestha, that means the father-in-law of the Immunization Ram, late Immunization Ram. Because this Immunization Ram, my Lord, married Rana Pogestha, the son of Nishi Shekhar. Okay. So, at that time he came alone, my Lord, and he stayed at Malki, a rental house at Malki.
Okay.
In 1924-25, his elder brother, Chandra Shekhar Pogestha, after finishing his studies from Dehradun Forest College, joined the service of forest ranger at Shillong. On coming to Shillong in the year 1924-25, he, along with his wife, my Lord, and children, one son with one daughter, joined the mess of Nishi Shekhar Pogestha in a rental house at Malki, Shillong. That means his brother. Then, my Lord, in 1934, myself and my elder Nishi Shekhar Pogestha and his elder brother jointly purchased a suit land of 14,110 square feet from one Ramala Bose. Then, my Lord, in 1936-37, Nishi Shekhar Pogestha was married while staying in a joint family in the said property. Then Rana Pogestha was born at the residence in the said property, my Lord.
Who is this Rana Purgasto?
Rana Purgasto, my lord, was the husband of that Emily Sindra.
Okay.
Both of them are died now. Then adjacent plot of land measuring more or less 2,500 square feet was purchased out of the family fund from the Kundong Maori in the name of Chandra Chekapueso, who is the Karta representing the family. Our case, my lord, is that Chandra Chekar Puesto was the Karta of the family, my lord. And that has been specifically stated in our written statement also. Then Chandra Chekar Puesto left the post of forest ranger to join United Nations in Bangkok and the Middle Eastern and St. Paul at Darjeeling. So I think we refer to now, my lord, I would like to refer that in 1934 was jointly purchased 14,110 square feet from one Ramula Bose. That, my lord, is appear in page 43 of the additional affidavit, bringing on record in TS number 236 T of 2013, my lord. This is the serial, my lord.
Yes.
And there, my lord, in page 44, my lord.
Yes.
Page 44 of the additional affidavit filed by them.
You're referring to?
The additional affidavit, my lord, filed by the petitioner, my lord. Additional affidavit filed by the petitioner.
When was the affidavit filed? When was it filed?
13 June, my lord.
13 June. In which case? In this one or the other case? That too?
This was 13 June. You received it. Sometime in June, my lord.
Just a moment.
It was filed on 13 June, my lord.
Yes, yes. Yeah, no, it's in CRP 10.
my lord.
Yes, Mr. Kanji, you're referring to this affidavit and
Then I would like to refer to that schedule number, page 44. Page 44.
type copy is at 54.
44. Or type copy is in 47, 47, madam.
No, the schedule?
Schedule page 47.
47 schedule. 47.
Yes. Yes, please.
Regarding description of property, situated at Lime Crash along and beyond as follows: north, east, south, west. And they have given the measurement also. I would like to refer, my lord, that on the south, my lord, it is by public road, and that is 135, my lord. 135.
Yes.
This is the crux of the matter, my lord. 135. Then after we purchase this, then we purchase also another portion also on the north, which is reflect in page 48, type copy, my lord.
Yes.
On 16/10/1946. They have purchased another plot also on the north, 2,500 square feet, madam. Then in 48/49, madam, Chandrasekhar Vugeshwar left the post of forest ranger to join the UNO in Bangkok and admitted his son, Timothy Vugeshwar, in Singapore. Then 48/49, another double-storied Assam-type house was constructed over the Bakan portion of the Sutland. Then Nishi Pugeshto, along with his family, shifted there.
Yes.
So, my lord, when they bought that land, then in 34, they construct a single-storied house jointly, and then they stay together. Then, my lord, in 1948-49, another double-storied Assam-type house was constructed over the Bakan portion of the Sutland. Then Nishi Pogishto, along with his family, shifted there. Then regarding the 52, he was in Kolkata. Then in 1953, Chandrasekhar obtained Pata in his name as Karta, representing the joint family from Thomas Midlame, the regency landowner, on 5/2/53 with transferable heritable occupancy for 99 years, renewable up to every 15 years. Then in 1969, Rana Pugeshto is a long-standing teacher of St. Anthony High Secondary School, who was born and brought up there even after marriage to Emily Sundram in the year 1969. He continued to reside in the house along with his wife and 3 children. In 1969, madam. Then in 1979, the elder brother died, my lord, in Kolkata.
Okay. Yes.
So during the lifetime of the brother, my lord, there is no dispute, there is no jikri-jikra, my lord. Then in 1985, Nishi Pugeshwar, the brother, died at a residence in the Sud property, my lord.
Yes.
Then in 1937, my lord, Himantri Pugeshwar, I mean the son of Chandrasekhar, filed a TS case number 11T of 1907 for recovery possession value so and so. And in 1997,
Who is this Himandri?
Himantri is the son of Chandrasekhar, my lord.
Okay.
Himati Professor had illegally sold and disposed of a portion of land to Kilbat Sengchai, husband of applicant number 1, by deed of conveyance by way of sale executed on 04/06/1997, my lord. And that, my lord, is in that same thing that in the affidavit bring on record filed by the petitioner in CRP number 10 of 22. It is shown there, the particulars. The type copy, my lord, is in page 4, annexure 12.
Page 4.
Page 4, annexure 12.
Annexure 12 for what?
Annexure 12 of that CRP number 10 of 22 in the affidavit being on record. The registered sale deed dated 04/06/1997.
Just one.
Type copy.
This affidavit bringing on record registered sale deed dated 4/6.
Yes, ma'am.
1997.
4/6/1997.
Okay. So this is affidavit dated 10/5.
10/5.
Yes.
I will refer, my lord, to page 9 of that affidavit, my lord, of between record.
Page 9.
Page 9.
The schedule.
The schedule property, my lord.
Schedule A or Schedule B?
Note is Schedule B, my lord. Schedule B is a plot of land sold to Siang Chai, my lord. So there, my lord, north, east, south, west, my lord.
Yes.
So there, my lord, it is clearly stated that on the south, Laimkra main road, the measurement is given, my lord, is 129 feet, my lord, and not 135, as per the study from Ramala Bose. That means that is 6 feet different, my lord, 6 different. And that is, my lord, is an approach road to my house, to the south land of the.
That's 6 feet.
6 feet. 6 feet is in the from the side of the Lamkram main road. It expands there, and near my house around 10 feet. My lord. So this is the thing, my lord. So it is very clear, my lord, that Kilba Siang Chai did not bought 135 feet. It was only 129 feet, and that 6 feet is a provision provided for the approach road to the land of Nishi Mana, Nishi Sekar Patachaji Mana. Then, my lord, in the declaration given by the wife of Gilbert Siang Chai also, my lord, which is in page 17.
Yes. page 17.
17. This deed of declaration is made on 22nd so you hereby declare the following fact and keep the factual portion into writing and record more fully and specifically described in the schedule hereunder written for the purpose of registration in the office of Register at law. Whereas I am the legal owner along with the RTC building so and so. And then whereas the said land posted RTC building and some type of house was inherited by me from my deceased husband, Gilbert Changchai, madam.
Yes.
And whereas I have never alienated so and so. So what I want to show here, my lord, is that the schedule property. And here also, my lord, the wife of Gilbert Changchai has clearly stated that on the south Limekra main road is 129 feet, my lord.
Yes. $129 feet.
129 feet. So, my lord, from the photograph also here in page 21 of that, so very clear. That is the approach road. 6 feet from the Limekra main road, and not that means total is 129, where not 135 as it was ordinarily. Then on 2001, my lord, TS number 236.
So, Mr. Kenjing, Mr. Kenjing, this at page 21 is the photograph.
Yes, my lord.
Page 21 is the photograph.
Yes.
This shows a path going from the main road towards the building.
To what?
Towards your house or
my
whatever.
house.
So now this part is 6 feet.
Yes, my lord. According on record, my lord. On record. Because ordinarily it's 135 and it was purchased by Gilbert Changchai 129 only, my lord.
Okay. Yes, please conclude.
It is in TS number 1070 of 2017, my lord. It is 6 feet at the entrance and 10 feet at the edge of the entrance. That means near my house. And that is understanding, my lord, is the right for approach and egress and ingress, my lord. Then in 2001, my lord, the TS case was filed for a direction to the defendant, that means to the government. The government didn't appear.
Who's there? Mr.
Last time they appeared.
The sub-registrar, isn't it?
You are appearing for him?
He's appearing for the private respondent.
He's for respondent 4.
Chaji is appearing, was appearing. KP Chaji.
What happened to you?
Just check.
Anyway, please continue.
I'll continue, my lord.
Please continue.
That, my lord, for direction to the complete registration of seal deed dated 17/11/2000, making registrar as defendant and run-up registrar as pro forma defendant.
This, if I understand correctly, what was submitted by Mr. Karim is only for the purpose that the since the said seal deed was not registered, so direction to be given for registration.
Yes. Okay. So, my lord, I was made a pro forma defendant. Then I have filed my lord a written statement disputing the claim of the plaintiff, my lord, and so hence I was a regular defendant, my lord. And in the written statement, my lord, I have stated everything, my lord, that he has no right and title over this land, and the ownership lie with me. Ownership and possession.
That particular 6 feet.
No, my lord. That this what he pray.
The whole land as such.
But the should land. That means
The portion which the respondent is under occupation, my lord.
Occupation, my lord. 5,460, my lord.
But that is not disputed by him.
No.
No, we are not disputing.
They are fighting for recovery of it.
We are not disputing that they are in possession, my lord. A suit for recovery has been filed by the previous owner.
Yes, they have filed a suit for recovery. For that also we have filed a written statement. And written statement is more or less the same, my lord. That he has no right and title for that particular, for that certain land. So once you have filed in, my lord, that means the question of title is involved.
See, in this whole area, if I understand correctly, there are 2 plots of land, 2 separate plots of land. You are residing in one part, and the petitioner is said to be in possession of the other part.
Yes.
So now he has approached the authority, particularly the sub-register, for registration of a document pertaining to the portion which is said to be in possession.
No, my lord. My lord,
that also, because they have filed 2 cases, my lord. And the 2 cases are same case also.
No, I'll just clarify, my lord. My lord, the total area which was under the possession of the original order, who had sold to me a portion of it, was 16,650, my lord. Okay. Out of 16,650, 11,187 was sold to me on 4th June 1997, my lord.
Yes, so
that is plot, we can say like plot A is 16,650, plot B sold to me is 11,187, and plot C, the remaining portion, 5,463, is in their possession, my lord. This 5,463 was all, that also has been entered with me, my deceased husband and the father of the performer respondent number 4. We had entered into a sale deed. We had in 17 November 2000, the same was presented before the sub-registrar for registering, my lord. Because of the objection put forward by the respondent, this sale deed has not been registered, my lord. So that's why we had approached the trial court under section 77, my lord, for direction for registering it, my lord.
Okay.
So that is the entire thing. So now, my lord, the suit which has been filed by me is in respect of 5463.
Okay, 5463.
For registering it, my lord. So on that particular suit, my lord, miscase was filed by them for injunction, my lord. So only point which I have raised is, my lord, under section 77 of the Registration Act, the miscase will not be maintainable, my lord. So that's the only point, my lord.
But okay.
That it is not simple as that only, my lord.
No, my lord, that is the.
It may not be as simple. It is.
So that is the entire fact of the entire case, my lord.
The entire case is quite different, my lord.
Because as far as the land which is under their possession, which is 5463, my lord, in respect of that land.
So title suit is pending.
Yes, my lord. The ejectment suit has been filed.
Yes.
Against
and they are
them.
contesting, so fine.
My lord.
That will go on.
I will take your lordship
yes, that will go on.
To the plaintiff.
No,
please continue.
That has been tried together, my lord, by order of the High Court. I'll come to that also, my lord. I'll come to that. When you finish the order of the High Court.
Both suits were directed to be tried together, my lord. We are not disputing that also, my lord. But the only thing here is, my lord, the order which has been obtained by the respondent has been obtained on my suit, which is under section 77.
Why tried together?
Because my lord,
Separate cause of action.
it's totally separate cause of action.
It's not matter in different cases. It's all this. It has to be tried together. It's the same subject matter right from the beginning.
Because there are two transactions, if I understand correctly. As regard the 11,000 plus, there's one, and the 5,000 plus, there's another.
My lord. As far as 11,187 is concerned, my lord, they are not disputing it, my lord.
Oh, you're not disputing.
No, they are not disputing it. They had not raised any objection to it also. I have already constructed two buildings over that plan of land, my lord.
So the dispute is only with that 5,000 plus.
5,000.
5,464.
For which you are in possession.
Yes, my lord.
And this is an approach road through.
They are, what my senior is contending is, my lord, that the approach road which goes
to that 5,000
to the 5,000, including that 11,000, my lord.
Okay.
Same road, my lord. So the road starts from 11,000.
Part of that.
Yes, it's part. So like it's this kind of a square plot. So you have to pass through that. My plot only, the first plot, the 11,000.
That you have shown in your
yes, ma'am.
In the pictures.
Yes,
but what is now what I think their apprehension is that the path leading to their house, which they are in possession, would be controlled by you by erecting the gate. So, but you have assured that it would not be so.
Yes, madam.
The
We have assured that we will give them a key to that effect also, madam. That is on record.
As long as your egress and ingress is not disturbed, what is your difficulty?
My lord, why? What right they have? This what right they have to make a kid there? It is clearly 135, and I have bought only 129.
That's the contention.
So let's put it this way: if they choose not to erect that gate, then the matter is solved, as far as that approach road is concerned. Isn't it so?
Even now, your lordship will see from the
there is no gate.
There's no gate because of the injunction order, madam.
Because of the injunction.
Yes, madam.
So if you give up your claim or intention of erecting the gate, then they will have no more case.
That's true, madam.
You can pursue the suit differently.
Yes.
That would be that would be a matter of trial.
Madam.
As to your question of title ownership and possession, that's a different thing. But now, as far as the list is concerned, this particular list is concerned, it's only with regard to the
injunction,
to the injunction pertaining to the erection or non-erection of the gate.
My lord is absolutely correct.
So why don't you give up your claim and pursue the suit as a whole?
No, my lord. My contention is that the portion in which the gate is to be erected, that lands fall within this 11,187, my lord. They are claiming that that this is part and parcel of that suit land, 6 feet, whatever, my lord. My lord, I'll show your lordship in their entire pleadings, the written statement filed by them in the original suit of the ejectment suit, there was no claim as such, my lord. Even in the subsequent suit filed by me, my lord, there is no claim whatsoever, my lord. It is only when they have seen that I was constructing the gate, at that point of time, they had filed an injunction and brought up this particular issue, saying that this is 6 feet is part and parcel of the 5,463 plot, my lord. 16 years, my lord, not even a single word has been uttered by them with regard to the 6 feet.
I will reply that 16
years.
Let me also reply. My lord, that suit for recovery was filed by them in 1997. And from 1997 till date, they have examined only one witness, my lord. And that witness is very vital, my lord. That witness is the grandson of Chandrasekhar. And he has admitted the existence of the approach road to the house, and then there is no dispute. I'll read the whole statement of that witness, my lord. So, my lord, since 1997, they did not do anything, and there's peacefully. Meanwhile, my lord, now they have made an endeavor to squeeze us out by making all this unnecessary obstruction, my lord.
Okay, that is your apprehension.
Not apprehension. That is actually what I'm doing, my lord. I'll satisfy your lordship. There are so many violations of court order also. When they ask them not to construct anything, they just construct it in spite of the court order. And when we file a petition, then they say we have to stop. There is quite different of the approach road at that time and now, my lord. And that is a part and parcel of the suit property, my lord. So, and over and above, there is a decision of the Honorable High Court, my lord, in which they have stated that in page 28, my lord, of the objection show cause on behalf of the upset party number 123, my lord.
That is page
28, my lord.
28.
28 in civil revision number, in this case number 15 of 2020.
Where is it?
Civil revision petition number 10 of 2020.
Yes, this is it. You have filed a show cause.
Before the High Court? Yes, my lord.
Yes.
That is that of course is for in connection with section 10, my lord, because they want to stay. So I'll go through the paragraph 2, my lord.
Paragraph 2 of this petition, of this show cause.
Of the judgment of the Honorable Court, 20 of the
page just
28.
Yes. Yes, page 28.
So, my lord, in paragraph 2, my lord, of that judgment is regarding the case of the petitioner. The main source of petitioner is that the subject matter, the parties, and the issues involved in both the suit are the same. That is my contention, my lord. The right, title, and interest over the suit land between the petitioner and the upset party in TS number 11T97 is to be decided first, then only a decree in TS number 39T01 can be passed directing defendant to register the impinged deed. Though in TS number 39T were added as party being upset party number 2 and promoter upset party number 3, but the party cannot agitate the matter independently without the upset party. Therefore, all the ingredients section 10 of the CPC, that is my contention, my lord.
Yes.
So I'll come, my lord, to P30, paragraph 9, my lord.
Yes.
In title suit number 39T 2001, which is read number 236T of 2013, pleading were exchanged by the parties and were on the file of the Land Assistant Deputy Commissioner's law. On the basis of pleading, several issues were framed which are quoted as hereunder. Whether it's cause of action for filings and whether it's maintainable, whether it's court has decided. And then I would like to refer to that D, madam, one of the issues framed. Whether the plaintiff is the owner having a valid title over the suit premises, madam. So that is there also, right from the 1997, my lord. And this is the same subject.
Naturally.
Now, my lord, I'll go to the operative part of the order, my lord. Which is in 26, my lord. 25 and 26, I'll read together, my lord.
Page?
40, my lord.
Yes, 25, 26. Yes.
In the present case at hand, though there is no action pleading in TS number 11T of 97, but the fact remains that the case relates to eviction from the suit premises, whereas the subsequent suit number 39T 2001 relates to registration of the sale deed dated 17/11/2000, being refused to register the same by registrar. The above fact clearly discloses and also establishes the relief claim in TS number 39T is absolutely distinct and separate from that of the earlier suit. Therefore, there is no illegality committed by both the court below in rejecting the prayer for stay of subsequent suit being TS so-and-so and no interference so-and-so. Then this is operative paper. In my considered opinion, and in order to avoid multiplicity of suit and conflicting judgment, this court direct that Assistant to Deputy Commissioner Shillong to try both suits together. The petitioner directed to file written statement as required under the code of CPC within a period of 3 weeks from the day of their appearance, and the trial court will proceed with both the case simultaneously and dispose of the same as expeditiously as possible. The parties shall appear before the court of Assistant to Deputy Commissioner, my lord. So in this case, it is very clear, my lord, that written statement also has not yet been filed, so issue has not been framed properly in the other case. But the fact remains that since that time, my lord, with the order of the High Court, the case is to be tried together, my lord. So now this case are tried together. So it cannot be said, it cannot be done in isolation that this is regarding registration, this is for recovery, my lord. This is a case of, there is only one, as it is now, it is only one. It is a combine of the recovery and the registration, my lord. And the issues have been framed also in both the cases, my lord. And in page 60, my lord, 5960, it is a written statement filed by the defendant, Rana Priesta, my lord. So from 1 to 19, my lord, it is
Yes.
is averment which I have denied.
Yes.
And then my case start from paragraph 20, my lord, page 62. That the plaintiff and the defendant are the cousin. Plaintiff is the son of the father, elder brother of the defendant by relation. Both the parties originally hail from Habiganj in Sylhet district of erstwhile East Pakistan, now Bangladesh. Defendant father, late Nishi Shekhar Puesto, were five brothers in all. Defendant father and plaintiff father were two brothers among those 5 brothers. Defendant father was younger while plaintiff father was elder brother. The defendant father came to Shillong in the year 1920 and hired a rented house in Malki area of the town. The defendant father was doing business at supplying bamboo and railway sleeper, staying in the said rented house at Malki, Shillong town. The plaintiff father, late Chandrasekhar Puristho, after finishing his studies from Dehradun Forest College, joined the service of forest ranger at Shillong. On coming to Shillong in the year 1924-25, he, along with his wife and children, one son and one daughter, joined the mess of defendant father in the said rented house at Malki in Shillong. So this is the case, my lord, that the Nishi came first in 1920, and my elder brother, after he finished from Dehradun Forest College in 24-25, then he joined Assam service in forest, and then he come and stay with me, with the Nishi in the same bus, along with his wife and one son and one daughter. Then the plaintiff father was staying in a joint family, purchased a sod land measuring more or less 14,110 square feet from one Mrs. Ramala Bose on 22/12/34. The plaintiff father, being the elder brother, the said land was purchased in his name as Karta of the joint family. Although the defendant father contributed money for such purchase, after purchase of said land, an Assam-type house was constructed out of the joint family, including the defendant father, shifted there. So after they constructed the house, my lord, they shifted there. Then while staying as joint family, the defendant father married, that means Nishi, married in the year 1936-37. The defendant only child of his parents were born in Sutland in 1939. The plaintiff father, that child is Rana Puyastha, my lord. The plaintiff father had two sons and two daughters. They are Srimati Deepika Roy Chaudhary and Sri Rajat Puyastha, and Srimati Deepika Venkatarajan, daughter. And the plaintiff's son, the family plaintiff father and defendant father remain all along joint kin in common. The plaintiff sister so-and-so reside in Kolkata, and then since it's long back, and his elder brother Rajat Puyastha residing in USA. Another adjacent plot of land measuring more or less 2,500 square feet was purchased out of the joint family fund on 16/10/46 from one Kandong Maori in the name of the plaintiff father, as was done earlier. It may be mentioned here that after purchase of such land, the plaintiff father, late Chandrasekhar Puyastha, obtained pata in his name as a karta representing the joint family from Thomas Midlem, the recently landowner of Lime Khara Shillong, on 5/2/53, with transferable and heritable right occupancy for 99 years, renewable after every 15 years. That the defendant was born on such land, he married there, and having 3 sons, of 2 are married. That means Nishimara. Since the date of his birth till today, the defendant is living in such land with his wife and children. The defendant is a teacher by profession, and he has retired from St. Anthony's School, Shillong. While staying in the such land, the defendant father, Nishi Shekhar Pugastha, died in the year 1985. And his mother, late Priti Lata Pugastha, predeceased her in the year 1976. The plaintiff father, late Chandrasekhar Pugastha, left the post of forest ranger under the then government of Assam the year 1949. He joined the United Nations in the year 1949 as food and agricultural expert, East and Far East, with headquarters in Bangkok. At the 11th time, the plaintiff was a small boy. The plaintiff father left Shillong forever and went to Bangkok in order to save. That this small boy, my lord, is Himadri. In order to save the United Nations organization, keeping the plaintiff kin a boarding school, namely St. Paul's School at Darjeeling. The plaintiff father constructed a house at Kolkata in the year 1951-52. Since the time of his admission in St. Paul's School at Darjeeling, the plaintiff never came to Shillong for stay. Even on vacation also, he went to Bangkok. On finishing his education, the plaintiff is doing business permanently at Kolkata. The plaintiff father died in Kolkata in the year 1979. The defendant father, Nishi Shekhar Prasad, was a shareholder in the then Shillong Banking Corporation Ltd. He also maintained an account at said bank. He contributed his share of money. This is very important. He contributed his share of money while constructing the single-storied Assam-type house over the said land. The entire family, both the plaintiff father and defendant father, resided jointly in the Assam-type house. Thereafter, another double-storied Assam-type house was constructed over the vacant portion of Sudland in the year 1948-49. At that time, when the plaintiff father joined the United Nations, there was an amicable settlement between the two brothers, plaintiff and the defendant, as a result of which the plaintiff father got the single-storied Assam-type house with proportionate area of land, and the defendant father got the double-storied Assam-type house with proportionate area of land. With Assam-type house. As the plaintiff father was leaving Shillong forever, the Assam-type house was given on rent to tenant. The plaintiff father, along with family member, left Shillong and requested defendant father to take care of their house and landed property in their absence. Thereafter, the defendant father, and after his death, the defendant used to collect rent from Assam-type house and deposit the amount in the account of the plaintiff father, and after his death in the account of the plaintiff. That out of the aforesaid plot of land, measuring about 14,110 square feet, the defendant is possessing only 5,463 square feet, and the remaining portion was under the share of the plaintiff.
How long will it take, Mr. Finjay? I think we are into lunchtime now.
Okay. We'll continue.
We'll continue after lunch.
The written statement, my lord, in page 64. 64 in civil division number 10 or 22. In this case, number 15. This is from our show course, my lord.
Yes,
My
sir.
lord.
It was here just now. Name. Yes, so you are.
We have continued, my lord, in the page 64, the current activities of the father, Nishi Shekhar Progressor. The defendant father, late Nishi Shekhar Progressor, was a shareholder in the then Shillong Banking Corporation. He also maintained an account in the said bank. He contributed his share of money while constructing the single-storied Assam-type house over the Sutland. The entire family, both of the plaintiff father and defendant father, resided jointly in the said Assam-type house. Thereafter, another double-storied Assam-type house was constructed over the Bakan portion of the Sutland in the year 1948-49. At that time, when the plaintiff father joined UNO, there was an amicable settlement between the two brothers, plaintiff and defendant father, as a result of which the plaintiff father got the single-storied Assam-type house with proportionate area of land, and the defendant father got the double-storied Assam-type house with a proportionate area of land. The defendant father, along with his family, shifted to the double-storied Assam-type house. As the plaintiff father family was living Shillong forever, the Assam-type house was given on rent to tenant. The plaintiff father, along with his family member, left Shillong and requested the defendant father to take care of their house and landed property in their absence. Thereafter, defendant father, and after his death, the defendant used to collect rent from the Assam-type single-story house and deposit the amount on the account of the plaintiff father, and after his death, in the account of the plaintiff. That means during lifetime and Chandra Chakar, thereafter to his son Himadri. That out of the forested plot of land measuring 14,110 square feet, the defendant is possessing only 5,463 square feet of land, and the remaining portion was under the share of the plaintiff. The area plaintiff that he is the plea plaintiff that he is the owner of the suit land by Bilchu Rapata issued by landowner is baseless inasmuch as apart from the plaintiff, his brother and two sister defendants also derived share in the suit land. The plaintiff alone could not have been entitled to get a pata in respect of entire land. Moreover, since plaintiff is out from 1950 from Sutland, he could not have got the impinged nesta. It may further be mentioned that after 23/10/82, the plaintiff never renewed the pata. As such, he lost his right over the land on 23/10/97. The alleged pata, if any, was obtained fraudulently behind the back of the defendant, and as such not as in law. That other plea of the plaintiff that the property was inherited by him on the basis of the affidavit sworn by his father, brother, and sister surrendering the property in his favor are not correct, and the same is baseless. The alleged affidavit is not genuine, but has been created without in mind for the purpose of the case. The defendant begs to state that the share of the property belonged to his brother and sister does not bear on plaintiff by virtue of the said affidavit. Now the plaintiff played fraud on the defendant in contending that he entered into a caretaker agreement on 3/12/85 with the defendant, authorizing him to look after and manage the landed property of the plaintiff as and when as a caretaker and to deliver hand over a key of said house to the plaintiff as and when he has to do so. The defendant never executed the impinged caretaker agreement. The alleged caretaker agreement is fraudulent manufacturing document of the plaintiff. The fraud is evident in the alleged caretaker agreement as it is without consideration against the service rendered by the defendant. Rather, cost and liability of managing the property has been imposed on the defendant. It is
These are all assertion of facts.
Yes, my lord, but it is
Not part of the pleadings, my lord. Not part of their pleadings in both the written statement filed in the ejectment suit as well as in
But this is a part of the written statement only.
No, my lord.
Anyway, even if it is so, I don't think this court will go into that.
No, my lord, because the genesis of the case, my lord, is such that it has to be.
You are relating only the history of the case.
Yes,
Fine.
the genesis has to be directly with this affair of the case. The plaintiff sold an area measuring 1,100 along with the house standing thereon, which they could as their share against the defendant in favor of Kilbat Singh Chai by registered sale date Exhibit 4697. Because that credit show also how much they sold also and what are the line also from the Ramkra Road, how much, man? It is 129, and whereas the original is 135. 6 feet is not the that's why it has to be, this thing are important, my lord. That on the next day, executing the first sale date, the plaintiff again on 5/6/97 entered into clandestine agreement for sale in favor of Kilbat Sanctuary in respect of the land which defendant is possessing in his chair. And that is where I stay also, that they sold it, my lord. Then I will read the P66, my lord. The plaintiff, thereafter, plaintiff and the said Kilbat Sanctuary as plaintiffs 39T/2001, the court of filed in the court of Ireland SNDC against the defendant, and the said registrar praying for direction to direct defendant to register sale deed. The defendant has appeared and said and filed in statement narrating the fact that the plaintiff is not the owner. This is what I want to emphasize, my lord, that the plaintiff is not the owner. I have raised that in my written statement. Because they have stated that there is no counterclaim there, then the written statement, my lord, is nothing but a counterclaim only. Here, the plaintiff is not owner, and he doesn't have position as such, he has no right to sell. Whereas the plaintiff is not owner, he doesn't have position, and he has no right to sell, my lord.
Yes.
That there in the before sub-register also, my lord, when they asked him to produce the board on him, any document, nothing, my lord. That's why the sub-register has passed an order that goes to civil court to determine this, my lord. This is on record, my lord. That the defendant will state that subject matter parties and issue in both the suit TS11 and TS39T are same. Decision the first suit will decide the other suit.
Yes.
Statement again. Now I have stated also, my lord, that since 1997 they have never brought any witness except one, my lord. And his statement, his deposition also I have in page 26 of 25 and 26 of the show cause, my lord.
Yes.
Dear my lord, from the cross, my lord, Leonard, so, The original pata plaintiff is my father for both the cases, one for recovery of possession and one for registration of sale deed. So this deposition clearly states that one case has now been combined to one. I have gone through both the plain and written statement of both the cases. It is a fact that, except the pata issued by the landowner, we do not have any legal document or instrument in the name of.
You're reading page?
Yeah, page 25, my lord.
Yes, please continue.
This Manipur my lord, is the grandson of Chandra.
Yes.
Chandra. So he says it's a fact that, except pata issued by the landowner, we do not have any legal document or instrument in the name of my father. I am not aware that question of ownership and title with regard to the property has been decided by the court or not. It's a fact that there is no order from the court declaring my ownership and title over the said land. Then, my lord, I am a Bengali Hindu and governed by Hindu law. Late Chandrasekhar Pugasto was my grandfather, and late Nishi Shekhar Pugasto was the brother of my grandfather. I cannot recall that my grandfather and his brother were residing at Marquis Law prior to the purchase of the property. It's a fact that my grandfather was in government service, and his brother, late Nishi Shekhar Pugasto, was contractor. Then I was not born at the time, so and so. Then my lord, I'll come to page 26, my lord. It's a fact that my grandfather and his brother, late Nishi Shekhar Pugasto, were residing together while my grandfather was in Chilo. So that is the statement of his grandson, my lord. Then he denied that there are two holding. Then it was. It is a fact that did Chandrasekhar Pugasto and did Primada Sundari Pugasto were my great grandfather and great grandmother. It's a fact that my great grandmother and great grandfather had two sons, Sashi and so and so, and Nishi Shekhar Pugasto, and subsequently Sudhar Pugasto and Himanshu Pugasto. That means his father. It's a fact that my grandfather, being the elder, is a karta as per Hindu law. That is the statement of his own grandson, my lord. It's a fact that my grandfather, being the elder, is a karta as per Hindu law. It's not a fact that my father did not produce a title document over the supra. It's a fact also. Then my lord subsequently said that my grandfather died in the year 1978, predeceased my granduncle, who died sometime in the year 1945. It's a fact that my grandfather, late Chandra Pugasto, never asked my granduncle, late to vacate the said premises. So I have stated also right from the beginning that during the lifetime of his younger brother, there is no such dispute. It's a fact that my grandfather never asked my granduncle, Nishi Shekhar Pugasto, to vacate the premises. My father, right from childhood, was in a boarding school studying at Darjeeling. Then it is a fact that my granduncle, late Nishi Shekhar Pugasto, has been residing in the property for many decades prior to the year 1985. It is a fact that my grandfather, late Nishi Shekhar Pugasto, while residing in the property, our children were born and brought up in the property. Then it's a fact that late Rana Pugasto, the original defendant, died in the property, and I know that he was married and had children. I am that fact is just not going to say this. Then I rely on the seal deed dated 22/12/1934, executed between my grandfather and Mrs. Romara both in respect to property. If it is the same seal deed based on which pata was given to my grandfather, and also a deed that I rely on the content and statement made in the seal deed. I agree with the suggestion that in the schedule of the boundary, I agree with the suggestion that in the scheduled boundary executed on 22/12/1934 in the south by public road 135 as per the said date. So during the time Ramalam it is 135. Then I agree with the suggestion that in the scheduled boundary executed under so and so on in 1934 in the south by public road 135 as per schedule said date. It's a fact that portions of property was sold by my father by registered sale deed on 5/6/1997. And there also a boundary of the property has been described. And there also a property. Then this is very what I want to emphasize, madam. It's a fact that there is an approach road from the Lime Club main road to the said property. Then it's not a fact that it has no right about the property. So this is the important matter. It's a fact that there is an approach road from Lime Club main road to the said property. So my lord, this grandson of original of the elder brother has stated before the court, and this is the only one who stated, and he has stated also that it's the fact of my grandfather being the elder is the karta as per Hindu law. My lord. So one thing I would like to refer also, my lord, that this case, when we filed the written statement, also, because we did not receive, because it was filed. I refer to the civil revision, the petition filed by them, my lord, in civil revision number 10. A type copy, my lord, in 30A.
Page
30A, 30A, my lord.
Yes.
That copy, my lord. By the plaintiff was received by the counsel for proper defendant only on 22/3/2002.
Just a minute. Yes, 30A. Please.
Only on 22/3/2002, whereas the court notice was dated 21/12/2001.
Yes.
What do I like to emphasize, that thus the proforma defendant was deprived of the opportunity to be heard because it was filed beyond time, my lord. For this reason alone, the suit is liable to be dismissed. The counsel proforma defendant had to receive the copy of the application for condemnation from the court, as the processor bar gave the report that he returned the notice and someone because he could not locate the resident of proforma defendant, Sri Rana Pugesa. The proforma defendant strongly challenges the report of the processor bar as totally wrong and baseless. Strangely, the processor bar could not find the house of the proforma defendant, a prominent and old resident of the locality, and who is a long-standing teacher of St. Anthony High Secondary School, Shillong, and who was born and brought up there, and even after marriage in the year 1969, he continued to reside in the said house along with his wife and his still 3 children. He was born and brought up there and all of them have attained age majority. So, my lord, right from the time of inception of this case, my lord, there is a play, my lord, that even if the court issued no court notice on 21/12/2001 on the plea that the processor bar could not find him, in spite of the fact they stay only so near there in the main road, and he was a teacher of St. Anthony and married to a Khasi lady also. Then they say that he could not be, that ultimately the lawyer has to receive inside the court, my lord. So The inception, also right from the beginning, my lord, does not show that anything that show the bona fide act of the petitioner, my lord. Here I would like to that the Learned Assistant to DC, my lord, in her order in page 87, my lord.
87.
87 of the deposition.
Yes.
This
is the impugn order.
No, this is not impugn order.
This is one of the impugn order. But this is the order which by which the interim injunction was made absolute. That has merged with the final order passing the FAO.
Merged with the final order also. Anyway, my lord, because I'll just show that this very fact also have been placed right from the Assistant DC in 2017, my lord. Learned Counsel so and so for the applicant submitted as the father of plaintiff number 1 and the defendant both deceased jointly purchased two properties measuring about 14,000 square feet and 2,000 square feet, a part of which is now formed Sutland, situated at Lime Crash Law. Both the father jointly constructed two houses on the above plot, and the plot was obtained the name of the Karta of the Hindu joint family, namely the plaintiff father. It is contended that the family settlement was arrived at by the father, the plaintiff, and defendant, whereby Sutland was divided among them, by which the plaintiff received a plot with a single-storied house standing thereon, and the defendant received a plot with a double-storied house thereon. Then, by way of this sale deed dated 4/6/97, the plaintiff number 1 has sold 11,187 square feet to one Kilbat Sangchai, who is now deceased and represented by his wife, Helen Khar, plaintiff number 2. Opposite party number 3 to the miscase. It is also submitted that the above plaintiff number 1 has sought also to sell off the portion of the Sutland which is in possession of the defendant, for which he has filed for recovery position in the eject GS number 90 of 2013. In the above sale deed, the Learned Counsel pointed out that the portion of the Sutland and the schedule in the schedule mentioned 129 feet south facing the Lime Crab main road. Learned Counsel had relied on the document annexed to the plea of the instant cert, that means on that document, out of which the misapplication arises. It is also contended that the new TS 2017 is being filed by them under compulsion to protect the right of easement and right of way of the plan to Sutland. It is submitted that approach road measuring 6 feet wide at entrance near the public road and 10 feet wide at the edge of Sutland was never sold off to the opposite party dead husband, nor was it used by the applicant disturbed for 20 years up till now, when Sri Srimati Helen Khar authorized construction of a gate on the approach road leading to the property. Then the council also questions so and so and does not have any right to. Then per contra, my lord, the opposite party, the council of opposite party questioned the act of the applicant defendant, submitting that they have not shown any document that have any semblance of title but so and so. Then, having had a document, then it comes to page 89.
Page
89. The operative portion. Apparently, there was no dispute when the father, plaintiff number 1, and defendant were alive.
Yes.
Further, for 2 decades, no issue had ever cropped up between the party and the user defendant of this approach road until now, when the plaintiff number 2 tried to erect a gate at the entrance of the Sutland. Irreparable loss would be caused to defendant if the injunction is not granted, as their egress and ingress would be disturbed, since there appear no other road from which they can enter and exit the same desert land. The opposite party, number 2, has also failed to prove that there is an alternative path for use of defendant for the accuracy and inquest. Clearly, irreparable loss and harm would be caused to defendant if the affliction is dismissed, or more so as the issue are yet to be decided and evidence remains. If the opposite party plaintiffs have sought the erect decade, we have taken into consideration the fact that the 2 decades the approach road has been used and still being used by defendant to offer handing over a key to the disputing party. If at all any nuisance by the public is sought to be prevented, the parties would have resorted to other means like putting up a sign warning trespasser. There is also no obstruction to the plaintiff from putting barricade on the side property currently under her possession. Hence, at this juncture, without going into the merit of the case, it can be concluded that the balance combination tilted in favor of the applicant. So, Your Honor, right from that time, they say that it is a public nuisance, but it's not a single document before the police to show that there is such thing, my lord. And this miscase is disposed of, and that only has been made absolute. And thereafter, my lord, again that order, they have preferred an appeal to the Additional Deputy Commissioner. That in page 103, my lord, of the Civil Division number 10.
Yes.
So that also same fact has been placed, my lord. So in the appeal, my lord, they have stated that the inherited entire landed property at Longrim Road, Lime Crash along, out of the inherited landed property, a portion of the land measuring so and so was sold to Himadri. Was sold by Himadri, plaintiff number 1 to plaintiff Gilbert Sengchai by sale deed, and the same was registered before the office. Thereafter, the remaining portion, so and so, madam. As such, Himadri plaintiff has instituted a recovery of portion. Then we have filed also the show cause, madam, in page 107, madam.
Yes.
On receipt of the notice issued by the court, Srimati Emerson Rem, Robin Professor and Kubin Professor, respondent applicant, filed a joint show cause stating that the 6 feet wide approach motorable road exits to the Lamkra main road and 10 feet at the edge of the entrance to the property has all along been used by them and their family member as egress and ingress right to their house and compound, and that is the only way wherein the respondent applicant and their family member were using the said approach motorable footpath without any disturbance, interference, or interruption from any quarter whatsoever for the last so many decades, since the time of Nishi Pugester, the father-in-law of Imedi Sundam. Then, my lord, paragraph 13, that the boundary of property toward the south Limekra main road is 129 feet, whereas original pata dated 28 July 1930 of Sebastian Bia and Thomas Perdon, the distance towards south Limekra main road is 135, which goes to show that the 6 feet width approach motorable road path was excluded from the boundary of the property alleged to have purchased by late Gilbert Sengchai. That from the said document of the property itself there is a 6 feet width approach motorable road toward the landed property. The said 6 feet width approach motorable road was the only way to which the respondent applicant and her family member can enter and exit to their house and compound, which was never disturbed or interfered at any point of time for so many decades. It was only on 23rd August 2017 that the petitioner of party number 3 and her son, with a delusional belief that it was a part and parcel of the property, they started to clean the same and illegally dig the part with intention to install iron gate at the main entrance exit of the Lamkra main road. which compelled the respondent to file Miss Case 90T of 2007, seeking interim protection from the court to restrain the petitioner of opposite party, number 3, from interfering with the right of way with egress and ingress of the respondent toward the house and compound and the Learned Trial Court by the ex parties dated 24/8/2017 was pleased to restrain the plaintiff for continuing with the illegal activity. That subsequently, by order 30/10/2017, the trial court was pleased to make the interim injunction absolute. So the lower court has already made the interim injunction absolute by order on 30/10/2017. It was further pleaded that since the 6 feet width approach motorable road is never disturbed or interfered for the last so many decades, and the same was all along under the peaceful use of the respondent applicant and their family member as their easement right to their house and compound, and as stated by the respondent applicant in the written statement to both the civil suit filed earlier and the plaintiff eject so and so and so, the plaintiff did not file any counterclaim with regard to the 6 feet by approach because of the admitted portion of the fact which on record that the deceased husband or the petitioner of party number 3 did not purchase the said road at all, and that is on record the part was never included in the deed of conveyance so and so, and that a part in the eject zones 90 of 2013 and TS number 236 2013. Also, the petitioner of party number 3 completely remained silent about the 6 feet width motorable road part. In both the cases below, my lord, they are silent regarding this 6 feet. That from the first factual portion of the property, as narrated above, prima facie existing 6 feet width approach motorable road path from Limecraft Main Road leading to the house and compound respondent applicant, though not directly connected with the sub-property, but the fact remains that petitioner of party number 3 never claimed the said motorable road path as our property at any point of time. Nor did the document rely by the petitioner of party number 3 indicate that the road path is included in the land of petitioner of party number 3. And that too in both previous suit filed with the petitioner who had not made any statement made, abandonment or claim that the said 6 feet with approach motorable road path belonged to her property as such. The illegal act and claim made by petitioner of party number 3 only for in the month of August 2017 become a new subject matter of dispute which need adjudication determined by the court, as otherwise the claim petitioner of property that 6 feet wide motorable road path is a part and parcel of her property and has no leg to stand without order of decree from any competent court. Then in 110, my lord, in paragraph 18, I have carefully gone through the memorandum and it appears that impinged order on trial has been asserted on 22 number of grounds. Then, point of examination, considering all aspects of fact and law, in application of for appeal and show cause, find the following point were formulated. Whether the impinged order 30 passed in Miss Case number 90 2017 by trial court is unjust, illegal, and improper. Discussion. Has submission of counsel of both sides produced the record is settled principle of law that relief temporary injunction is temporary relief in order to succeed in an order 39 rule 1 and 2 CPC, the petitioner has to prove the following: that the petitioner has prima facie case that irreparable loss or damage will result in the event of refusal of grant temporary injunction, and the balance convenience also in favor of the petitioner. In the background of the above principle, I hereby proceed to decide the case in hand. It may be pointed out that during the course of hearing, Sri Land Constable petitioner of Subsidiary number 3 argued that the miscase application on 39 rule 1 and 2 filed by the defendant is not maintainable as there is no specific pleading, and that the connected TS number was filed by the plaintiff under section 77 of the Decision Act 1908. That means the same ground they have raised now, raising for a decree for direction to defendant to complete the registration commemorative sale date dated 17/11/2000. Learned counsel for petitioner contended that the suit filed under section 77 is not a general suit but is a specific suit where the suit cannot entertain the miscase petition under so and so. As the petitioner as a party is agreed the injunction order, I hereby reproduce the provision of the Order 39 Rule 1 CPC. Order 39 Rule 1. where in a suit it is proved by affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged or alienated by any party to suit or wrongfully sold in execution of a decree, or the defendant threatened or intend to remove or dispose of the property, the defendant threatened to dispossess the plaintiff or otherwise injure the plaintiff, the court may by order grant temporary injunction to restrain such act or make such other order for the purpose of staying or preventing the wasting, damaging, alienation, removal or disposition of the plaintiff or otherwise cause injury to plaintiff in relation to any property in dispute as the court think fit under disposal or until further order. Then, he has gone through also the citation and principle of the above 39 Rule 1. It is clear that from clause A of Rule 1, by the expression of any property in dispute is in danger of being wasted. Then, the word used in clause A is wide enough to indicate that an injunction application filed by the defendant and that the court can entertain such application filed by the defendant in the property in dispute and suit is in danger of being wasted, damaged, or alienated by plaintiff. So, in the citation, in Liberty Sales Service, petitioner Bessa so and so, SEC Online, Delhi so and so, the Honorable High Court of Delhi held as follows. In Sukanda by so the question is this: whether the defendant can move an injunction against the plaintiff without filing counterclaim or issuing a writ in a cross action. In my opinion, he can in some cases, but only in cases where the defendant claim to relief arises out of the plaintiff's cause of action. The plaintiff claim to relief arises out of plaintiff cause action. Buckley Justice also referred to the view of David L. Lord Justice in Crystal versus Fee to the following effect. In my opinion, it must be relating to arising of the relief sought action which is before the court, and that any other injunction cannot be properly granted as action. The case was followed by the Kolkata High Court in Ashish Ranjan Das. If the defendant application for injunction were in any way connected with, so this is what I emphasize. If the defendant application for injunction were in any way connected with or incidental to the object and purpose of plaintiff action, we would have a good ground contention. On principle of above order so and so and the above decision, the Honorable High Court Delhi is clear that the defendant can move for injunction against the plaintiff without necessity of filing counterclaim if subject matter dispute arises out of the plaintiff action or incidental thereto. The plaintiff cause action or incidental to it. Furthermore, seen that there is no provision in the Decision Act which bar the defendant to file an application on the Order 39 Rule 1 CPC in a suit filed by plaintiff under Section 77. Coming to the fact of circumstances in such case, prima facie appear from the pleading of the parties that there is no dispute that respondent applicant are in possession of the land measuring about 5,463 square feet, along with the house therein mentioned in Schedule B. Further, it appears from the document annexed to the plea, in part of the annexed deed dated to 22nd December 1934, executed between Ramolad Bose and C.R. Purester, who is the father of Himadri Purester, plaintiff number 1. The boundary of the property toward the south is 135 feet, while the deed of conveyance by way of sale deed dated 4 June 1997 executed between Himadri and Kilbat Sangchai, and the deed of declaration 22nd day of June 2016 made by Helen Dehar, petitioner of supervision number 3. The schedule of the boundary of the property toward the south connecting the Limekra main road is at a distance of 129 feet. It appears that there is 6 feet motorable road path leading from the landed property to the respondent applicant toward the south, connecting Limekra main road and property under the occupation of the respondent applicant. Has all along been used by the then and their family member as egress and ingress right to their house and compound, which is the only way where the respondent applicant and their family member were using the said approach motorable road path without any disturbance, interference, or interruption from any quarter. Then, my lord, after considering all those things, then he has come to the conclusion that considering all outstanding facts and circumstances of the matter, the petitioner of supervision number 3 have failed to make out any illegality any illegality, error, or perversity in the impeached order of the Learned Trial Court.
Yes.
Any illegality, error, or perversity. So my contention, Your Honor, that even before this Honorable High Court also, he has not shown anywhere the illegality, error, or perversity in the impeached order. So in view of that, the appeal stand disposed on contest, my lord. I would like to rely also, my lord, in the decision of the in 2024 County Law Report 62. The Fisuddin petitioner versus
2020. Yes. GLR for 62.
This book we have already.
Yes, yes, I've got it. Para?
So now welcome, my lord. Regarding because my learned friend keep on saying counterclaim. Order E, Rule 6A, counterclaim. Para 17 to 21, my lord. In respect of the point of determination number 2, is seen that respondent number 1, here is the plaintiff and the petitioner being the defendant number 1, had filed a counterclaim. In the present case at hand, the written statement against the counterclaim or petitioner was filed on 22. In the case of Ramesh Chan Ardawatiya versus Anil Panjwari, it has been held by Supreme Court of India that the counterclaim must necessarily find a place in the written statement. Paragraph 28 of the said case as follows. Looking at the scheme of the Order 8 as amended by Act number 104, we are of the opinion that there are three modes of pleading or setting up of counterclaim in a civil suit. Firstly, the written statement filed under Rule 1 may itself contain a counterclaim within the light of the rule. So, my lord, in this case, also I have filed a counterclaim. I have filed a written statement, and there, right in both the written statement, I have stated that he has no right, has no the ownership and possession of that 5,463 is with me only. That I have clearly stated in my written statement, my lord. So to say that the counterclaim will be filed, my lord, it is there in the written statement that it has been filed. It's a detailed written statement. Because counterclaim run with the right of filing written statement. Written statement already filed. Had we have not filed written statement, of course, thing will be different. And overall, also, I would like to apprise you, my lord, in spite of all the interim injunction from time to time, they have violated time and again, and they have to go to court. So to say that they were handed a key to me also is far from truth, my lord. And over and above, my lord, right from 1997 till date, they have produced only one witness. I would respectfully submit, my lord, that at least I will submit that the case be had expeditiously, my lord, that all the way. Otherwise, one petition after petition, and how to find ways and means how to squeeze me by making a case another, it will not be the remedy, my lord. In view of that, my lord, the petition filed by the revision petition, madam, is, as a matter of fact, it's not maintainable also, because if it is to be, will decide once for all, it's okay. But in this case, my lord, it is not like that. is a case of missed case and over and above the lower two court below have kept different and have kept decision of finding my lord that that 135 and 129 is a big difference and the approach road is very much there, my lord. In view of that, I pray that the petition be rejected, my lord.
But small reply, Lord.
We'll hear the other respondent first.
Lord.
Yes, who's appearing for respondent 4? Yes, what is the submission? You have no role to play in what sense? And why have you said that you have no role to play? So tell me, what is your stand?
But in this case, the evidence also was given by his by the grandson.
He is the witness.
Yes.
So you are aware of the facts and circumstances of the case?
By him only. That evidence we have just produced before the court.
Okay. Totally.
Your Lordship, the dispute is just between the petitioner and the respondent, Your Lordship. We have no role to play in this matter.
But you have deposed in the trial court. You have deposed as a witness.
Lordship, I don't have the briefs with me, Your Lordship.
In respect of the ejectment suit, my lord.
Ejectment suit.
Yeah, not in this 236, my lord. Not in my case, my lord.
Yes.
He said that he is not over and above that he is already a party and the case is be tried together only. Issues have been framed also together. So he cannot anyway, that is his submission. That he is not
because so both these cases, one is with regard to the ejectment suit, and the other is with regard to the registration.
Yes, sir.
So they are tagged together.
They are tagged together, no doubt, but the different course of action, my lord, because we are seeking. The other suit is for seeking for ejectment of the respondent, whereas in my suit is for registration of the sale deed, which has been executed me and the father of the pro forma defendant number 4. So there are two aspects of it, different, because as far as title is concerned, because the seller, the respondent, the pro forma respondent number 4, the father of the pro forma respondent number 4 is the seller, and my husband, my deceased husband, was the purchaser. Both of them have signed the sale deed and have presented the same before the registrar. It is just because on the basis of the objection filed by the respondent that the sub-registrar has refused to entertain the registration and has passed an order saying directing the parties to approach the civil court. So that is the only issue. It's not a case where an agreement for sale has been executed. Then I go to court under section 77 for specific performance. That is not the case in this case, my lord. This is totally a different case altogether. The refusal of the sub-registrar is only on the basis of the objection filed by them. It's only on that. Had it been a question of an agreement for sale whereby the seller has refused to execute a sale deed, then a suit for a specific performance will come into play, my lord.
My lord, I reply for that. In this ETS 39T of 2001, my lord, human reprogressor is a plaintiff. along with Gilbert Sengchai. I can district registrar, I can me, Rana.
Yes, he's a plaintiff because he's the one who has signed the,
Yes,
who was a
But the only
signatory to this sale deed.
yes, ma'am. But the dispute, as far as the present dispute is concerned, with regard to the gate, that's what I've submitted earlier also, my lord, that this portion where the gate is proposed to be erected falls within the boundaries of this 11,187. I will show to your lordship the 6 feet which they are claiming. They cannot claim beyond the pleadings, my lord. Their pleading or my pleading, my lord. I'll reply to that, my lord. Because that will make it very clear, amply clear. Because if they are saying that the 5463, the land which is under their possession, whereby the suit for ejectment has been filed, that the schedule itself clearly shows that on the southern side of that particular land, the land belongs to Gilbert Sanchai. It's not that 6 feet. We'll have to go as per the pleading, my lord, if that's the case. That's what I've stated right from the beginning, my lord. They have not filed any counterclaim. In their written statement to the ejectment suit also, it's a normal rebuttal only. That's it. They have never mentioned as far as the 6 feet is concerned. This is after 16 years, only when they had filed this present miscase for injunction, only at that point of time they have brought it forward, my lord. That was not part of the pleading, not even in the original suit, the initial suit of ejectment, nor in the suit filed by me under section 39, where I have mentioned specifically in the schedule, my lord, what are the schedule and what are the boundaries which have been bounded by this particular. If that would have been the case, they should have contested because they were pro forma defendant. They have filed a written statement, so normally they will be a defendant now. They have not contested the schedule for which I have proposed to register the sale deed, my lord. In this particular sale deed, the schedule is very clear. Since my senior has mentioned it's in the southern part of it. The southern part, it's very clearly written that compound of Gilbert Siangshai, my deceased husband, my lord.
I reply to that, that cannot be in isolation like that, because what they purchased that much only.
Absolutely. I'm saying that only, my lord. What we have purchased is 5463.
Yes.
So 5463, if my lord goes to at page 26A of my revision, it is very clear, my lord. Schedule B. This is the land which is proposed to be registered by me. If my lord come to 26A, they are not disputing 11187 has been purchased by me. So my lord, we'll see 26A, Schedule B. This is the land, this is my suit, my lord.
But you have not indicated the measurement or the area against each.
5463.
No, that is
26A.
That is the total. See, north, how much is north, how much is.
No, that you have not indicated. We have just given the total area only, the schedule only. My lord, the south is the concern, because on the original south is Laimukra main road. Now in this case, south, it's compound of Gilbert Spankside, because on the southern part, my lord, that 11187 has already been purchased by me, my lord. So south originally in the 11187 which was purchased by me, it was Laimukra main road. So after I have purchased it, my lord, so south becomes the compound of Gilbert Spankside. That means like this is the land which has been purchased by me, my lord. So that is the southern portion of it, my lord. So this is the schedule of the land where it was proposed to be sold by me. So this is the schedule where we have sought for registration of the sale deed. And this is the schedule of the suit which is before your lordship.
Yes.
My lord.
So now this is questionable. It is still to be proved.
My lord, that will be
by
a
way
way
of
evidence,
trial.
my lord.
And
So what I'm saying, my lord, since because they are claiming that there is a 6 feet path. Nowhere, if my lord goes through their written statement in the original suit, I have annexed that there was no whisper about it. Even in reply to this, they should have replied to this particular suit of mine for registration, whereby I have clearly mentioned south compound of Gilbert Sangshai, clearly showing that the land in the southern portion belongs to me, to my deceased husband. Now it belongs to me. So if that would have been the case, they should have contested that in the south it should have been not the land of so and so, either the land of Gilbert Sangsha along with 6 feet. That would have been the claim, my lord, if at all. My lord will go through the written statement filed by them. In both the suit, there is no whisper whatsoever about that 6 feet approach road, my lord. It's only when they had filed this miscase for injunction that they have brought this particular fact to the court, my lord. And not only that, my lord, they have also filed a suit. They have filed a fresh suit, my lord. After the injunction was given, they have filed a suit with regard to this 6 feet footpath, my lord. So that suit is still pending. We have already filed an application under Section 10 for stay of the application, saying that the same subject matter is pending before the court, my lord. So, my lord, clearly it shows that this is an afterthought, and this is a prayer which have been made by me after 16 years against me. That ground have been taken by me, my lord, in my civil division also, my lord. So, my lord, if the issue before your lordship, as I have stated earlier, is with regard to the maintainability of the miscase, which has been filed by me in the suit. They have filed a miscase, my lord. As the other day, my lord, we'll see this 1999-7 SAC 114, my lord. This decision of the Apex Court, section paragraph 10 and 11, will clarify everything, my lord. What kind of suit can come in section 77, my lord. In as far as I am concerned, my suit is not for specific relief. My suit, which I have filed, is exclusive remedy for allowing for a direction by the court to allow me to register the sale deed. If it's not a comprehensive suit, so had it been a comprehensive suit or a suit for specific performance, then definitely I cannot argue or I cannot object to the miscase for injunction, my lord. That would be maintainable. In this case, my lord, since the suit itself is for exclusive remedy, so the miscase for injunction would not be maintainable, my lord. So the paragraph 10 and 11, my lord, the other day also I have read out to this honorable court, this citation 1999-7 SAC 114, my lord. This clearly clarifies the entire position of law, my lord. Whether when injunction can be filed, in which particular suit, my lord.
Yes, who's appearing for what is state? Yes, tell me. Yes. What is your authority on that? What are the provisions either in the CPC or the Registration Act which say so? And where's Mr. Sangota? Very unfortunate. Yes, what we will do is since your argument has already been concluded, except for respondent 3 and 4 has already made assumption. You can file your written synopsis.
We'll do that.
Because the authorities or the list of books that you've given, you can just cite the authorities.
Nice.
And on the next date, we'll hear the respondent 3.
Well.
1 week?
week's time will do. There's nothing much also. There's just the registrar, sub-registrar who had refused to.
For filing of the written argument?
Oh, written argument? No, 1 week will do that.
Mr. Kanji?
My senior.
Maybe 2 weeks, man.
Huh?
2 weeks.
The counsel for petitioner as well as the respondent, as well as the counsel for the respondent number 2 and 3, or you have 2?
Yes.
2 and 3.
2 and 3.
Two and
One
three.
is died.
One has expired.
One is you have for 2 and 3.
2 and 3.
And the respondent and the registrar is?
Registrar is 5. Performer respondent number 5.
Respondent number 2 and 3 have also been heard elaborately. How the respondent 4 has also been heard. However, the respondent 5 is not prepared with the hearing today and has sought for accommodation in this matter. Since the matter has been substantially covered through the submission of the principal parties herein, the submission of the respondent 5 will be heard on the next date fixed. In the meantime, the parties are allowed to file their written argument in this case. As prayed for, this is matter up to 2 weeks.
No pleasure.
That's right.
Item number 11.
Yes.
So please, Your Lordship. Your Lordship, I'll start with reading the FIR from the paper book, Your Lordship. Page 1 of the paper book.
This is a case of conviction.
Yes, Your Lordship, but it's a revision petition.
It's a revision petition against the concurrent findings of both the trial
Both the
court and
trial
the
and the
appellate
appellate
court.
What are the findings?
The finding is convicted also for
That's what I said.
offence of trespass and all, and he has already paid the fine. Fine was being imposed, challenging that before Your Lordship.
Your Lordship, what actually happened is that, Your
Fine has
Lordship,
been imposed and
paid.
Then
Your Lordship, what happened is that, Your Lordship,
the conviction, the sentence is only on for payment of fine.
Your Lordship, 7 days imprisonment or payment of fine. Your Lordship, what happened is that here the appellants or the petitioners herein, they have filed an application under section 3983 of the CRPC, wherein they informed the court that they will be filing an appeal and for bail, Your Lordship. However, that was rejected on the ground that one of the offences is a non-bailable offence, Your Lordship. However, Your Lordship, the trial court had failed to see that the imprisonment was only for 7 days, Your Lordship. However, Your Lordship, bona fidely, they had made the payment of fine. Because, Your Lordship, if they had not made the payment of fine, that was rejected, Your Lordship. So they would have been convicted. Thereafter, Your Lordship, being aggrieved, they filed an appeal. What happened is that, Your Lordship, after filing an appeal, the appellate court had dismissed on the ground that it has been infructuous. However, Your Lordship, again, there's a judgment of the Supreme Court wherein it says that even though the appellant has already undergone sentence, they can still file an appeal, Your Lordship.
That is false. That is always there. It's settled.
Yes, Your Lordship. So besides that, Your Lordship, the findings of the trial court, Your Lordship. Firstly, Your Lordship, in the findings of the trial court had convicted the accused persons only on the basis of the evidence of the IO and the complainant. Your Lordship, the IO has never made a sketch map of the place, never seized important materials, nor exhibited the same. Now, Your Lordship, even the statement of the complainant that was never corroborated. Another point is that, Your Lordship, the trial court had also failed to take into consideration that there was a civil dispute between the parties. And even the complainant in her cross-examination has admitted that there is a civil dispute, Your Lordship. Another one, Your Lordship, is that they have been convicted under Section 427. Now, Your Lordship, for an offence under Section 427, Your Lordship, what is important is that the complainant has to show that the property is in their possession. Your Lordship, now the trial court has relied only on the basis of the paper mark, which was not exhibited. It's very limited here, Your Lordship, the prayer.
So please start.
I read, Your Lordship. Complaint against Sri Donbok Suenso, Maya and Chembuam. With reference to the subject above, I have come to make a complaint against Donbok Buam, Maya Buam and Chem Buam since they have been assaulted me on 29/1/2018 at around 10:30 a.m. at Lat Jumplem village. This incident has also happened before because these people are jealous of her since she was gifted a plot of land by Raj Amwi Jaran since 2003. I have been using this plot of land since then, and no one has ever disturbed my peaceful possession. But on 23rd/1/2017, Donbok Buam, Maya Buam, and Chem Buam came and threatened me with physical harm and to also demolish my house. After they threatened me, I told them that if they have rights, they should proceed lawfully. However, these people came on 29/1/2018, wherein they had damaged the footpath leading to my house, and when I tried to talk to them, they have restricted me and assaulted me and even carried probably an axe or a wrecking bar, Your Lordship, to cause me harm. When I called my siblings, they stopped, and even the JCB, which was used to demolish the footpath, also stopped. However, this did not end here. On 31st/1/2018, Donbok Buam, Maya Buam, and Chem Buam brought the JCB again and have demolished my said property. And since they have already assaulted me, I did not dare to even say anything to them. In view of the above acts committed by Donbok Buam, Maya Buam, and Chem Buam, wherein my life is in danger and my property has been destroyed by these people, I have no other way but to request you to arrest these people and to punish them in accordance with law. Your Lordship, statement under Section 161 of the complaint, page 7.
Yes.
Examined her in connection with the above referred case, and she stated that her name and particulars are as stated above. On being asked by the women police, I give my statement voluntarily before police that on 29/1/2018 at 10:30 a.m., one earth mover JCB belonged to Shri La Lamin of Nongbare village has been working in the land and damaged my footpath. Then I called my brother Shri Tipormang Taryang, informed him about the matter. He came to the spot and called Shri La Lamin over the phone to stop working as he damaged the footpath, and Shri La Lamin called his driver to stop. Then the laborers got angry at me as they thought that I am the one to stop them. Then Shri Donbok Buam of Umlat Khor, Shri Maya Buam, Shri Chem Buam has threatened and assaulted me on the head and then fled away. That's all I have to say. Your Lordship, 164 is deposition, page 18, examination in chief.
Page
18.
Yes.
On 29th January 2018, at around 10:30 a.m., Shri Donbok Buam, Maya Buam, Chem Buam, and others, whose names I do not know, came with one JCB machine and forcefully broke the footpath leading towards my house. At that point of time, I called my brother, namely Shri Tipormon Taryang, to come to the place of occurrence. On reaching the place of occurrence, my brother called the owner of the JCB to stop the work. The accused persons, along with the rods, came towards me and threatened me. As I was alone at that time, I did not know what to do. I tried to talk to the accused persons. However, they did not listen to me, but they continued to justify themselves that the land belonged to them. I told the accused persons that if the land belonged to them, then they should have complained the matter to the court and not to take matters forcefully or illegally. One of the accused pulled by my hair, however, I do not know which accused person. On 23rd January 2018, Shri Donbok Buam and Maya Buam came to the PO and threatened me if I still continue to construct the house, then they will demolish the house. On 31st January 2018, around 10 people, along with 3 accused persons, came again with JCB and destroyed my footpath, veranda of the house, and the same date I went to lodge the FIR at Amlaram police station. Your Lordship, I'll read the cross. It is a fact.
This is 164 or this is
Examination in chief, Your Lordship.
Where's the 164?
164 is not here, Your Lordship. It's not there.
It has been, was 164 recorded?
I am not sure, Your Lordship, but it's not here in the paper book also.
Have you gone through the record? You should have included that. 164 is very important. Because whatever is stated, in the deposition in court would surely be based on 164 number 1.
Then Your Lordship, I'll just...
And also, if there is any contradiction or corroboration, then 161 will be taken. So those are important documents.
Then Your Lordship, may I seek instruction with regards to that, and this matter can come up after just a week?
You go through the lower court records. Go through the lower court records. It has to be there only. Go through it, then we'll take it up after 1 week.
Yes, Your Lordship.
Place this matter to 1 week.